Welcome today to our event, Why the EU Needs an Anti-Corruption Sanctions Regime. I know many of you are joining us online, as well as many people here in the room. It's a lovely pleasure to see so many people in person once again. For those of you joining online, a little bit of housekeeping. You should be able to type in your questions on your screen. We're using a tool called Slido. For those in the room, you will find QR codes that you can scan. And we're very egalitarian about this, so it gives the online audience the same opportunity as those in the room to ask their questions. I will be keeping an eye on them during our panel, so don't hesitate to type them in as soon as they occur to you. We're not going to stand on formality and make everyone wait until the end. We'll try and weave your questions and your priorities into our conversation today. Of course, we're talking about sanctions in a very disrupted world. We've seen regressive backsliding and authoritarianism around the world, regrettably. And of course, not least, the war in Ukraine has focused minds in a way that has not been seen in quite a long time, and in many people's lifetimes in that case as well. I'm going to hand over to introduce today's topic and give you a welcome and tell you why we're all here and what we're going to be talking about over the next hour or so, to Carl Dolan, who is Interim Director of Policy and Outreach at Open Society for Europe and Central Asia. Carl, thank you.
Well, thank you very much, Jennifer, and a warm welcome to you all on this characteristically chilly and grey day here in Brussels. To those of you joining online, I hope you found a warm space with which to view the events. And for those of you in the room, congratulations on making it this far. And I hope you're as impressed as I am by how we have transformed this humble meeting space. At OSF, we specialize in transformations, democratic transformations and other kinds of transformations. So I should probably not be too surprised at how my colleagues have turned this meeting room into a state-of-the-art television studio. So my profound thanks to, it's an invidious task thanking people, of course, but my profound thanks to my colleagues Nana, Mariana, Tabitha, Pearlie and Denise, who helped create this. It's impossible not to see the 24th of February this year as the turning point, the watershed, the Zeitenwende, as our German colleagues would say. For many, this is the end of an age of naivety in the EU's foreign policy. Naivety about how we see the EU's place in the world and about how the world sees us. This goes for our defense policies, for our trade policies, for our industrial policies, but it also goes double, I would say, for the EU's anti-corruption policy. Now, tackling corruption has long been a focus of the EU's external policies and programming. Billions of euros have been spent and much ink has been spilled over the years on providing financial support and technical support to governments and civil society around the world, with special attention, of course, paid to those countries in the Western Balkans and in the Eastern neighbourhood who are candidate countries or who aspire to EU membership. The EU, the External Action Service's document archive, no doubt, is full of strategies and action plans that point to the scourge of corruption in many countries and regions, complete with prescriptions and recipes for reducing its burdens. And this focus has survived despite the difficulties and sensitivities that it raises, and the reservations of some that it hampers our interests and hampers our ability to compete globally. Now, this is all extremely welcome and should continue. However, if there has been a measure of naivety in this approach, it has been in the perception that corruption is mainly a threat to good governance and economic development within the countries concerned, and that support for progressive and reform-minded elements within that society is all that is needed to bend the arc of history in the right direction. I feel we have been too little concerned with what might be termed the spillover effects of corruption, the effects of that corruption on the EU, on its democratic partners, and on our democratic systems. We have been too blind to the fundamentally transnational nature of corrupt networks. Now, sometimes these corrupt networks, for example, organized crime groups, are only concerned with economic benefits. The hollowing out of our democratic norms and institutions is an unfortunate collateral damage of this activity. What we are understanding more and more, however, is how corruption is used as a kind of economic statecraft. And what we mean by that is that the profit motive is not the primary motivation. Rather, the aim is to create patronage networks and economic leverage that can be used to influence political decision-making. Now, Russia has perhaps perfected this type of statecraft with the effects in Europe in terms of captured political elites that are all too plain to see. But another good but perhaps lesser known example is what is known as the Azerbaijani laundromat. This was a 2.9 billion slush fund and international money laundering scheme that was run by the Azerbaijani political elites over a decade ago. The aim of that scheme was to launder the international reputation of a regime that was guilty of serious human rights abuses by, among other things, bribing European parliamentarians, including those from Germany, Italy, Spain, and indeed Belgium. In return from payments from this fund, the politicians attempted to persuade their parliamentary colleagues to vote against Council of Europe recommendations on its human rights track record. And as election monitors, they also issued supportive statements about elections that had been rigged by the regime, elections that had been contemned by reputable organizations like the OSCE. Now, these actions not only tried to whitewash Azerbaijan's international reputation, but they also undermined core democratic institutions and practices in Europe, while providing further ammunition to a key authoritarian narrative or trope that democratic politicians are hypocrites who all have their price. Now, I'm pleased to say that all that is changing, and thanks to the war in Ukraine, but unfortunately for the Ukrainian people, we have finally recognized that it is time to go on the offensive against corrupt networks and actors before it is too late. We need to calibrate our actions so that we can target individuals and companies without escalating to full country sanctions or economic warfare. We need precisely the kind of anti-corruption sanctions regime that is under discussion today. This instrument will be an essential tool in that new, more clear-eyed EU mindset, and we need to make sure that it is used in conjunction and in coordination with similar legislation in the US, in Canada, in the UK, to make it as painful and disruptive as possible for corrupt networks all around the world. And I would direct your attention to something, if you have not seen it already, a report to which my OSF colleague Tika contributed. It's called The Magnitsky Sanctions at 5 Years. It was published a couple of weeks ago, and it looks specifically at this issue of how we need to do better in terms of coordination between all the jurisdictions that have this kind of legislation. We have to do much better indeed. So for all these reasons, we were delighted to see President von der Leyen's commitment in the State of the Union address a couple of months ago to putting a targeted anti-corruption sanctions regime on the statute books. And we are looking forward to the day when High Representative Josep Borrell announces that he is giving a mandate to the Council to start drafting the necessary legislation. And we very much hope that day comes sooner rather than later. It would be the perfect gift, I would say, to the global anti-corruption community if that mandate could come on the 9th of December, International Anti-Corruption Day, which is a little over 3 weeks away. In any case, we will be looking for the perfect Christmas gift. So with that thought of good cheer and gifts, I hand the floor back to Jennifer.
Thank you very much, Carl. And I think you've set out the main questions that we're going to try and tackle in this panel. As I said, we're going to have this panel discussion. We're having academics, we will hear from the External Action Service as well as think tanks to get different perspectives on how the EU can have a grown-up sanctions regime. There's a balance to be struck. Things need to be able to be flexible and move, but you can't keep doing things on an ad hoc basis. There needs to be some sort of actual concrete framework. We're going to talk about what that might look like, what that should look like, and what might be the considerations. So thank you very much, Carl. I'd now like to invite onto stage our two panellists that we have here in the room, and joining us remotely, I'm also happy to welcome Anton Mosienko, lecturer at ANU College of Law, and also Sandra de Waal, head of division for sanctions at the European External Action Service. And joining me here, we have Tinatin Tsertsvadzen, who is a senior policy analyst at Open Society, Europe and Central Asia as well, and Stephanie Muchai, who is program director for governance and anti-corruption at the International Lawyers Project. Ladies and gentlemen, thank you very much indeed. We are really keen to hear your thoughts. And I'm going to ask the same sort of opening lightning question to all of you to respond to. So it's simply this: what do sanctions attempt to achieve beyond the policy stated behavioural change? Are there other factors, are there secondary considerations that we should look at that might be a measure of success? Stephanie, I'll let you start with that.
I think firstly is to, first of all, thank you for having me and for that introduction. I think firstly is to create real and direct consequences. Sanctions provide an immediate impact, and they look to also have some long-term structural changes to influence the ecosystem of corruption. I think that sanctions also contribute to accountability gaps, especially in countries where there are dim prospects of justice, say there is state capture or weak rule of law or things like that, then sanctions are very useful with that regard. There is also, I think, very importantly, recognition and solidarity with victims, especially in those kind of situations that I mentioned, that sanctions allow that recognitions. Many times it's really hard to designate a victim of corruption, but I think that sanctions help towards that as well.
Your thoughts then on the same question. What are the beyond the obvious solutions or the obvious aims?
Thank you. I think the big part of the discussions on sanctions impact and objectives has been focusing on the behavioral or the policy change, which has been part of the principles how EU has designed its sanctions policies and likely will remain part of it. However, it has become a bit of simplistic way to look at the impact of the sanctions, and overall there is a momentum and there's a need to move from do sanctions work to how to do sanctions better. And when we use the targeted sanctions, we should always have in mind the jurisdictions, particularly what's the political economy of a given circumstances or in a given country, who are the enablers and what are the networks behind. And for this reason, I would add two other components beyond the behavioral change. The first one is a deterrence, by which we mean to increase financial, political and reputational costs to those who violate international law. And the second is stigmatizing, basically to disruption, to cut off their access to the Western financial markets, to disable their privileges by which they are benefiting. And I would be happy to elaborate on those two components during the discussion later on.
Thank you. Anton, same question to you. Beyond the obvious behavioural change, what are other factors that we need to bear in mind?
Hello, everyone. Greetings from Australia. Hope you can hear me well.
We can indeed, yes.
Excellent. So I think in line with Steph's and Tika's comments, I would highlight the wide range of effects that sanctions have. And what I'm about to say comes from a piece of research that I've been working on together with the International Lawyers Project and Steph in particular. And the way that I think about the effect of sanctions is to consider three main categories of impact. So you've got the direct impact of sanctions, which is asset freezes and travel bans. That's what sanctions say on the tin. You've got your bank accounts frozen and you can't travel to the country that sanctions you. But then there's a range of secondary consequences, and that is banks not touching you anymore because you're too toxic. It's other forms of businesses not engaging with you at all. It is also potentially increased media scrutiny, where you become fair game for journalists and your profile is elevated in the media. And then another third category that I would separate out is stuff that might happen in your home country. So you might face disciplinary consequences, you might lose your job, or in extreme cases, an investigation might be launched into you in a country that would normally ignore your behavior, but for the fact that someone like the US or the UK has imposed sanctions on you. So there's a pretty broad range of things that can happen.
Very much, I think, echoing the stigmatization there that Tika mentioned. Sandra, the same question for you from the point of view of the External Action Service. I'm sure you've got your own unique perspective on this.
Hello, Jennifer. Can you actually hear me? Because I do not have on the phone here.
We can hear you perfectly and we can see you. So.
Okay, awesome. Just so you know, I cannot actually hear Anton when he speaks. I could hear the other speakers. So I can say I definitely agree or can echo what Stephanie and Tina have been raising. I agree that the rather narrow perspective that has been traditionally used in EU policy, as in terms of we are aiming to have, towards a change of behavior, that remains true. But I do think we definitely go beyond that. Now, I think what we actually aim to achieve will very much depend on the very specific context. I mean, here we're focusing on the anti-corruption sanctions, but what we're, for instance, trying to achieve with our sanctions in DRC or in Russia will have so will be inspired by the actual specific context. So I don't think there is necessarily a one-size-fits-all answer to this question. But I would, in the specific case of anti-corruption, think beyond behavior, indeed looking for accountability, looking for deterrence, looking for some support to victims, or at least, if not more than the moral support. Those are definitely very relevant in that kind of context, if we would indeed have such a regime in the future. The one thing, of course, that I think is from the EU perspective is that, if we would have such a regime, the idea, of course, is that it would be complementary to the other work that we do to fight corruption outside of the European Union. We, of course, do work within the European Union as well, but outside of the EU, of course, in specific countries, we may have programs to support for anti-corruption efforts, be it legislation, be it institutions. So I think in every specific case, the idea would, of course, be that we try to either complement that work where it exists, or where we are unable to work in a constructive way, maybe we would be able to work via sanctions. Again, I'm speaking very much, as you know, in a hypothetical manner today, because such a regime does not exist. We will have to see indeed in how far there can be political agreement between member states to indeed go down that road. So again, I'm a bit thinking out loud here as to what could be the possible use of such a regime, or the possible impact.
Thank you. Thank you. Well, let me come back to Anton then to ask a question about the impact. Based on the research that you've been looking at and data from the UK and the US, what sort of circumstances make for the most impactful results, Anton?
Our research looked at the first 20 corruption-related designations under the Global Magnitsky Act in the US. And as I said, there's a pretty wide variety of things that could happen in theory. Now, some of those things, sad though it might be, never happen. We haven't seen examples of profound systemic change in countries whose public officials were targeted under the global Magnitsky sanctions. And it is relatively rare that sanctions have resulted in new criminal investigations against people concerned. So in that sense, not much has happened. Yet at the same time, as I said, there is a wide range of other forms of impact related to, as Tika said, stigmatization and the inability of people to access services that they would normally rely on. The problem with that is that it's really impossible to measure. So you've got, 20 targets. How do you know if they have been denied access to banking facilities? How do you know whether they valued their ability to travel to the US that they no longer have? Well, one metric that we have access to is evidence of people trying to challenge sanctions designations, either through lobbying, as for example Dan Gertler, an Israeli businessman, did, or through court processes like Roberto Sandoval, a Mexican official who was sanctioned under the Global Magnitsky Act, did in the US. So you've got examples of people who, on the face of it, if you look at publicly available information, you don't really know to what extent they were affected, but the proof is in the pudding. They go to courts and they seek the lifting of those sanctions. Now, in what circumstances are sanctions the most impactful? Well, I think the answer is pretty obvious in that if someone is reliant on access to financial and other services in the sanctioning country, for example, the US, the UK, the EU, then they're likely to care. If they have assets in those countries, they're likely to care. If the ability to travel there is central to their prestige and the reputation they enjoy back at home, once again, they're likely to take notice. If, on the other hand, you have someone who's perfectly content to live in splendid isolation back at home and not really engage with the world, then maybe they're not necessarily going to be impacted by sanctions in quite the same way.
Well, Steph, let me ask you to expand a little bit on that and these other sorts of beyond asset freezes, beyond travel ban impacts that we might see. What have you perceived in your studies? What have you come up with?
So in the same research, we found some interesting impact on designees, and one was the loss of political standing and influence. As soon as they were designated, then people didn't want to be around them or to do business with them. So that was at least a temporary kind of impact and loss to the designees as well. We had some people that, especially, for example, in the Democratic Republic of Congo, removal of political appointees' influence and power. So that was interesting to see. So that disabled kind of the network of political power for influence, where the designee was working with very high-level political persons. We've seen people in the same research removed from positions of employment, high-level political, that was in same DRC and in Nicaragua as well, and resignations as a result of sanctions as well, which was a good impact to note. We, however, saw conversely that there was no reputational consequence of some of them. So, for example, in South Sudan, one of the designees, his name was Ajing. He was accused of bribery and corruption with procurement contracts and things like that. And so what he did after he had been sanctioned is he went off and did all this charity work in the community and gave back. And so, of course, then the country took it personally and said, this is a wonderful person. He does wonderful things for the community. And that took away the reputational consequence. And then the government got behind him and said, you know, those contracts were for legitimate purposes. And so that was a converse effect, an unintended consequence that we didn't want to see. And then there was holding of public office, a senator in the Dominican Republic, who was also accused of bribery and corruption with infrastructure and restoration in Haiti, continued to hold public office and ran for office 2 years later, even with the sanctions as well. In Iraq, we also observed unintended consequences where the designee continued to enjoy political power and access. So he used to use his money to pay politicians to favor his business, and didn't see a change in that as well. So in that regard, the reputational consequences didn't quite kick off, but we were happy to also observe similarly loss of political offices, resignations, and also affecting businesses. We've seen incidences where lawyers, other service providers didn't want to continue to do work with the sanctioned individual, didn't want to put their businesses at risk. So I think it's been a mixed bag with that regard.
Some of those anecdotes are a little bit depressing, really. So, Tika, tell me, what might a clearer added value be for a specific EU framework? I mean, we do see some sanctions happening, but what sort of an anti-corruption sanctions sort of structure might see some real benefits?
Sure. So one of the things we have observed is that existing EU sanctions regimes, the country regimes or the global human rights regime, provides for sanctioning so-called financial and economic enablers. This is a term we use, but it can be used differently. The most recently, following Russia's invasion to Ukraine, EU sanctioned a couple of dozens of oligarchs. Prior to that, following Queen Myanmar, economic and financial enablers are sanctioned on those lists. And in 2020, following electoral violence in Belarus, also half a dozen of oligarchs are sanctioned on those lists. Now, while politically these designations stand on a high moral grounds, there is an issue Anton was mentioning here about litigation in the US, but in the EU, it's a very different story. At the moment, there are 50-plus cases from Russian oligarchs at the European Court of Justice, around a dozen cases from Belarusians, and the list goes on. So the designation by association on those lists for an oligarch for its role to undermining the stability in Ukraine or supporting military regime or repression in a given country is highly problematic if we are not able, if Council is not able to provide sufficient evidence to prove their guilt. And here it comes why we need anti-corruption sanctions regime. If there was such a framework in place, some of those designations would have been more justified on anti-corruption regime because oligarchs and kleptocrats, we allege that there is some corruption and bribery, money laundering going on there, so there would be much easier way to build the evidence and their role in corruption. And secondly, anti-corruption sanctions regime, which ideally it's thematic regime. EU has 4 other thematic regimes. What it provides is to detach itself from political sensitivity and bias. In October, US Treasury designated a network of oligarchs destabilizing Moldova. Now, if EU had anti-corruption sanctions regime in place, and if it had followed the US steps, it would have sent a very powerful signal to a candidate country, which finds itself in a very, very vulnerable situation currently because of the war in Ukraine. So this would be the added values, one of the few added values of anti-corruption sanctions.
Well, Sandra, looking to your perspective, how would you see the development of an EU anti-corruption sanctions framework?
That we cannot take it for granted that it will actually be happening. Can you hear me? I see a worried face.
No, we can hear you now, yes.
I'm sorry. Yeah, I'm very handicapped here. I'm trying to do this from the phone. Again, I cannot hear Anton, and I cannot really manage my interventions. Let's carry on. So, of course, what will be important if and such a regime happens, of course, the sanctions regimes are always a tool for common foreign and security policy, which, of course, means that it raises the bar as in what type of activities that we can go and sanction. There obviously need to be a clear infringement or a clear threat to the common foreign security policy objectives of the European Union. So this would have to be something that clearly significantly affects, for instance, rule of law, stability, democracy in a given country before we would be basically justified to intervene with such a tool. So I think that is important to remember. And coupling back to the intervention by Tinatin just now, so indeed, when it came to the undermining of Ukraine territorial integrity, we've taken another road because also we don't have an anti-corruption regime available, which is more the road to try and sanction those oligarchs who are providing basically through their activity support to the regime, considering that one of the aims of the Russia sanctions regime and Ukraine regime is to undermine Russia's ability.
I fear we may have lost your sound, Sandra. I think we've lost you. I'm guessing you can hear me because by your expression, but unfortunately we can't hear you. I'm going to come back to our other ladies on the stage and we'll see if we can get that, and I'll see if I get a thumbs up from our being able to connect with you again in a moment. Tika, let me bounce back to you and ask about what might be the added value, again, a similar question, in terms of anti-corruption sanctions, when we already have a very solid anti-money laundering law. Is there a complementarity? There's a lot of talk around anti-money laundering and developments of it. Where do the two sit together? How do they dovetail?
Certainly, we see anti-corruption sanctions, as it mentioned in the opening remarks, also as a complementary to other existing tools. Corruption, by definition, is a matter of law enforcement. It should be investigated by law enforcement. However, the corruption, as we know today, is transnational by nature, and existing laws, no matter how good they are in Europe, don't manage to tackle the transnational nature of the corruption. It requires cross-border cooperation, cross-border investigation, and there are many reasons why existing anti-money laundering laws don't work, starting from understaffing, under-resourcing, poor implementation of the beneficial ownership registries, which has become a big issue with the current context of Russia's war in Ukraine and subsequent sanctions. We have seen policy and legislative developments following Russia's war on Ukraine in these areas, but again, these are legislative developments, and we really need to see these things in action and to see how they will in fact be applicable in real life. Like human rights sanctions, anti-corruption sanctions can have a supplementary role, or can be supplementary to the criminal law, and you can have basically available different tools. In this way, it can be a whole of the government approach while tackling corruption at home and tackling it abroad. One fundamental difference between anti-money laundering legislation and anti-corruption legislation is that unlike anti-money laundering laws essentially target proceeds of corruption, while anti-corruption sanctions would target the perpetrators. So what we discussed before, the accountability bit will be more prominently featured here. So this would be more of a complementary nature rather than tackling all sorts of corruption that Europe is facing at the moment.
Anton, I'd like to come back to you and ask you about whether you have been able to pinpoint any specific reasons why particular sanctions have been ineffective. Is it to do with inconsistency in policy making? Is it something else? Is it, as Tika mentioned, there needs to be sufficient resources? What sort of reasons might sanctions policy be ineffective?
That unfortunately sometimes we do see sanctions that do not appear to be effective. And let me just check my notes. I think there were 5 cases out of 20 where we could identify no tangible impact. And those cases related to alleged perpetrators from Russia, Venezuela, South Sudan, and Iraq. And I think that selection of countries gives you an inkling as to what the issue was there. We're talking about people who are not well integrated into transnational business networks. Those people were public officials, and of course they had business interests, but those were primarily limited to the country where they operated. The country itself was, to put it mildly, not a US ally, with the potential exception of Iraq, where you had other country-related idiosyncrasies. There was, as I said, no particular reliance on the US that those people had. And so this is really, I think, an explanation as to why those sanctions did not have any particular impact. And one takeaway that could be gleaned from that is that when one thinks about designing an impactful sanctions policy, it might make sense to ask, okay, why would this person notice? And do they rely on, say, EU infrastructure that they need in order to carry out their activities? Because if the answer is yes, then you can target them because of their dependence, and it is more likely that they will notice the effect of sanctions.
Well, correct me if I'm wrong, Steph, but there's not really a lot you can do about the individual if they're not exposed. What can you do from the side of designing the policies and integrating a sanctions policy into the overall approach?
I think more consistency, first of all, in the approach. Magnitsky sanctions are used for different purposes. So sometimes to enforce behavioral change, disable operations, effect damage. I think these inconsistencies mean that the sanctioned individual is not even clear sometimes on the purpose of their being sanctioned. And I think that there's an overall perception that application of sanctions is arbitrary. So I think that consistency in the approach would be helpful to that. I think that also I would encourage countries that tend to make political consequences and bilateral relations a big factor when they consider when to apply these. The harm that causes is that, of course, critical designations are missed out on, and the opportunity to really take effective action against corruption because those considerations are put ahead of others. I think we could also use kind of a more holistic, ongoing, like live approach that captures the whole ecosystem. It's no easy task. I say that easily on a panel, but the actual work of it is actually quite difficult. But I think that if we begin to do the work, then we begin to see more impact in terms of the anti-corruption domestications. Also, the reliance on domestic processes is an issue as well that I think needs to be addressed. In our research, we found that a lot of the sanctioned designations were reliant on the initiation of a domestic process first, which is limiting with that regard, because sometimes we need the external processes to be able to get the accountability that we talked about in the beginning.
I mean, is this going to be complicated at an EU level by the nature of the EU with 27 different countries?
I think that there was a conversation last week about multilateralization of the sanctions. I think if we start to see more cooperation, I think the EU actually has a good opportunity having that kind of bigger country and uniformity, that they have the opportunity to do that compared with the US and the UK. So I think it's actually an opportunity for the EU. It might be some hurdles to get through the political considerations and all of that. But once that's established, I think it's a good opportunity for the EU, actually.
It's an asset.
Yeah, it is.
Let me come back. Sandra, let's see if we got a connection this time. I'm sorry we lost you halfway through your train of thought. Can we hear you? What were you actually mentioning last time? I think you were talking about how the EU might design a framework.
Right, Gil?
Yes, wonderful. We have you.
Okay, I have no idea what happened. I did not touch anything, I promise. Yes, I think what you were asking, what type of corruption would we tackle if we would indeed create such a regime? And I was just pointing out, of course, that we have the threshold of the fact that our sanctions regimes are common foreign and security policy instruments, which means that, of course, we need to be able to make the link between happening outside of our borders and in how far that impacts upon our own common foreign and security policy objectives and our interests and values. So that is why we would be looking at corruption that really meets a threshold of affecting the rule of law, stability, democracy in a given country before we would, I think, feel justified to use sanctions to move in there. Hang on, I've taken a few notes here. Right, in terms of, I thought I heard Stephanie saying about the issue of relying on domestic processes. I guess precisely the idea is not to do that, as you have sort of made some inroads into tackling corruption and misappropriation of funds in the misappropriation or SAC in 2011. Now, the success of those has been very mixed because indeed it's not always been easy to build upon national processes for a variety of reasons. So if we go down the road of a sanctions regime for anti-corruption, the idea would indeed not to be to link that to what is happening domestically. And that again links back again to the idea that was mentioned at the beginning of the talk about accountability, etc. The idea is, of course, that we would try to also intervene in places where that accountability is lacking. But again, speaking very much in a hypothetical context, where we have at least a staff that touches upon corruption, that is in Lebanon, where it is really specific to the abuse of state funds. Tackle rights regime for the very destabilizing kind of activities, or the ones that are either because they take on that kind of magnitude, or maybe because they are so systematic that they're already stabilizing per se.
Thank you, Sandra. I think we missed a couple of points of that due to a slightly fuzzy line, but I think probably we got the overall sense of what you were conveying. I see we have a question coming in online from our audience. Claudio Francavilla is asking, have you looked at the impact of sanctions against entities rather than individuals, in particular armed forces, mentioning there as an example the US sanctions against Bangladesh's Rapid Action Battalion? Tika, perhaps you could reflect a little bit on this idea of entities rather than individuals.
So the report we launched last week with our partners in the US, Human Rights First, Redress in the UK, and Raoul Wallenberg Center in Canada, and us here in Brussels, we looked actually the Bangladeshi designations as one of the most successful designations. There were extrajudicial killings taking place in Bangladesh, and following those sanctions from the US, the extrajudicial killings have stopped. It's interesting, however, that South and Central Asia, by the all four jurisdictions, is a blind spot when imposing sanctions. The Bangladeshi sanctions is the only sanctions imposed by the four jurisdictions and the most impactful, I would say. And the other sanctions imposed by the four jurisdictions is against one Kyrgyz individual, which is not considered the most impactful. So there is some evidence that those type of designations in specific countries do have a specific impact, such as we have seen. And I think there is a need to replicate some of those experiences on other countries and on other circumstances. As I said, it's important to factor a lot of the times political economy in a given context. Who are the enablers, how the system works to be able to target precisely.
Anton, let me ask you to weigh in as well a little bit on whether we have to have different sensibilities or considerations when it comes to sanctioning entities rather than individuals.
Well, in the corruption context, I don't think that we have seen all that many, if any, sanctions against entities in the same way as, for example, with that Bangladesh grouping. What we have seen is that occasionally you have a cluster of allegedly corrupt individuals who are designated together. For example, several members of the Gupta family in South Africa. But in that case, as Steph has mentioned, this is one of the instances where domestic proceedings were already afoot and sanctions imposed by the US followed later. So first you have the home country taking action, and then the US kind of joins the game and adds sanctions on top of that. And there you have a real question of, okay, what is the added impact of sanctions? Because if sanctions are a way of addressing impunity, maybe you should reserve them for cases that are not addressed by domestic justice systems. But that is, probably the closest that we have to a kind of entity designated in the corruption context. Now, of course, there's the separate issue of corporate entities, that's to say companies that are designated in addition to individuals. If you're a corrupt politician, inevitably you will have a range of companies that will belong to you, and you will hold property through those companies. So there's an important issue of sanctions enforcement there. You have a government that pushes out a sanctions list and says, Anton must be sanctioned. But if you're a bank, do you actually know what companies Anton has? There's a real enforcement and compliance issue there. What is the expectation of financial institutions in terms of investigating the companies that might be owned by a sanctioned individual? To what extent do they rely on centralized databases like WorldCheck operated by Refinitiv or other similar databases that kind of prepare analytics for them and say, here is the sanctioned individual and here are the companies that they own? I think this is very much a question that requires further work and study, because to a significant extent that determines the actual effectiveness of sanctions.
Steph, you mentioned the asset of the EU, multilateralism within the EU. How do you view the cooperation with like-minded partners, the UK, the US, Canada, Australia, who already have regimes in place? What might be the best way to proceed in terms of getting this broader global action?
I think in the research that Tika mentioned that was launched last week, it's not actually working very well. And so they made really great recommendations that should be strengthened, not just multilaterally, but also within governments themselves. You find that sanctions departments are pretty much working in silos, and they also need that intra-governmental cooperation and then scale up to the multilateral designations. One of the key recommendations, I think, is more transparency about their and proactive publication, of course, where possible, understanding that sometimes not all the information is available, but about their implementation experiences, about their research and things like that. I think that helps in terms of the shared information and availability of the information to be able to learn from it as well. I think they can do better at reaching out with stakeholders, including civil society, to be able to work together with regards to evidence and things like that. And then lastly, I think also the kind of evidence that they use. You find instances where they will sometimes refuse evidence that's not open source or things like that. And because of the limitation of those providing the evidence, they're perhaps not able to go as deep as a government would. And then that almost sabotages the designation. So I think those would be three key areas that I would flag to strengthen.
Tika, staying with the idea of evidence and argumentation, I mean, what do we say to those who say that, you know, anti-corruption sanctions don't actually coerce kleptocrats to change their behaviour and that they're ineffective? I mean, and how do you present that evidence? Who should you be presenting it to, and how do you gather it?
There are a lot of proponents on that side, and it's easier to be on that side because it's easier to defend that side, but I'll get on the other side to defend the other position. Like there's, for example, a study that UN sanctions against Zimbabwean or Ivorian officials didn't change their behavior, but it has affected their professional and private life. And to just build on what I mentioned at the beginning, the stigmatizing and disruption effect of the sanctions shouldn't be discounted, and they're very important. For example, anti-corruption sanctions could be used as a means to disrupt the networks. And this is not the most novel way of using sanctions. We have seen in early 2000s when EU and US basically they had the first horizontal regime on terrorism. Those regime wasn't particularly designed with an idea to change behavior of terrorist groups. They were designed to upend their access to the Western financial system to prevent their activities. Similarly, we have cyber sanctions in the EU, we have chemical weapons sanctions in the EU, and those sanctions, these are the groups of high criminal activities, and it will be very hard to imagine they would change behavior because of the sanctions, but they certainly are designed in a way to upend their access to the Western financial system. And one other thing I would like to add, maybe this might be a bit of a stretch, but anti-corruption sanctions could protect democracy inside the EU. This is not surprising that kleptocrats take their ill-gotten assets to keep them in the banks in the collective West, where there is a rule of law and independent judiciary. Corruption has been declared as a national security threat by the UK and United States. It undermines trust in institutions, it erodes the institutions, it undermines rule of law and democracy for what we stand for. And I think beyond the traditional understanding of corruption, we really need to look at the anti-corruption sanctions from these different prisms to tackle it at home and abroad.
Well, let's stay with sort of engaging outside of just the sanctions. And Anton, let me ask you about where do we draw the link with enabling space for civil society organisations, for journalists, for this broader public communication?
I would say there are at least two important aspects to this. One of those is the ability of civil society organisations to recommend sanctions cases, as it were, to the attention of the authorities. And in the US, we have seen a process that is essentially informal in nature, but rather effective, where there is an interface between the government, specifically the Treasury, and civil society organizations, and there is a way to submit packages of documents and seek a determination as to whether that merits the imposition of sanctions. Another important facet of that, which applies more to journalists, is that we have seen from our research that if you're a journalist who has spent a number of years writing about someone who's powerful in your jurisdiction, who has allegedly been involved in corruption, then having that person designated makes your life easier, because then you can write about that individual with greater freedom. It's not only your word, you have the weight of a sanctions designation by a major government behind you, so that provides you with a degree of potentially legal cover, in that you can rely on the fact of that designation, even though that might not be much, but it's something. And also it automatically elevates the profile of that person so that more journalists are likely to be paying attention. And so the consequences in terms of journalist attention to the individual who has been designated can really not be overestimated, I think. They are extremely significant.
Right.
Sandra, I want to come to you, I hope you can hear me clearly, with a question about how the EU or the External Action Service one might interact and get involved with civil society or with journalists and with other like-minded partners around the world in coming up with a regime. What sort of multilateralism, what sort of stakeholder engagement do you think is appropriate?
Right. Let me actually jump to the fact, let's work on the hypothesis that we do have a regime in place, because I think it's more in terms of, when we do listing proposals, when we are working on listings under that type of regime, such as the EU Global Human Rights Regime, that we had really helpful contributions from NGOs and civil society. Of course, we are open. We have a functional mailbox. We are open to receive material from different corners. That, of course, always bearing in mind that when it comes to the option of be it a sanctions regime, be it a modification of a sanctions regime, be it the adoption of individual sanctions, the last word always lies with the 27 EU member states in the Council. But that does not mean that it cannot be useful for us to receive and collect information from different sources, even if we cannot use, it turns out we cannot use the actual information in the format it comes to us. It might lead us to the right places to find it. When it comes to coordination with like-minded countries, I mean, this is obviously something that we've been doing for a while, and it has really taken flight, I think, in the last year. If I look at Belarus, Myanmar, Russia, Ukraine, where we really are sort of joined up with like-minded partners in ways that was not maybe the case before. Whenever we coordinate with like-minded partners, it means that we are basically looking politically in the same direction. So, of course, the political context will always determine how far you can work with like-minded partners and who actually counts as a like-minded partner. Joint action with like-minded partners does not always mean that we necessarily adopt sanctions on the same day or that we adopt the exact same sanctions. It does mean that we are broadly looking into the same direction. We are targeting maybe the same categories. We may take inspiration from individuals or entities that have been targeted by like-minded countries that were not yet targeted by us, and vice versa. So this very much, I would say, in an organic kind of process. It's not, it has certain procedural aspects to it as well, but it's very much the coordination with like-minded partners is very much part of an ongoing dialogue that never stops, and where simply new accents are being brought depending upon the context. Again, in the specific context of an anti-corruption sanctions regime, if and when the EU would have such a regime, it would definitely, of course, make sense for us to take inspiration from those, the US and UK specifically, who have adopted such regimes in the past. We're talking to them to see, what has worked for you, what has not worked so well for you, and how can we also translate these same ideas into our own systems, because, of course, the legal environments are not quite the same. The sanctions regimes and the sanction authorities on one side of the Atlantic or the Channel do not look exactly the same way. But there is definitely, I would say, a whole lot of joint action, or joint in the sense of a sharing of objectives and conversations how we can do to get in existing sanctions regime. And if we have a sanctions regime on anti-corruption, I think that would definitely be one of those subjects on which we would be engaged in close conversations with our like-minded partners.
Thank you very much, Sandra. It's given us a good idea of where you're coming from. Anrika Visser has an interesting question, saying, even if individuals don't have links to the EU, couldn't you make the argument that they shouldn't be able to shift their activities to the EU following US sanctions? Tika, what's your take on that?
Yes, absolutely. That's what is the whole idea of multilateralization or coordinated action of sanctions, even if that's why we need EU to have the corresponding framework to respond to the same type of violations, like Moldova I mentioned at the beginning. But when we looked at the data, the overlap between on corruption coordination was very low, at 5%. And one of the reasons I think for this is that the way US does anti-corruption sanctions, it targets the networks. While it's slightly more challenging for UK and EU particularly to target the networks, and by association designations tends to be more challenging in the EU. But overall, I would say it will be very important. EU has a corresponding tool to follow the like-minded partners when there are big cases and emblematic cases.
Thank you. And a reminder to audience that if you want to get a question in, do it quickly because we are running out of time. Steph, I'd like to hear your thoughts on that same question about UK. The EU hasn't imposed a specific sanction, but what about taking note of what our neighbours across the Channel or across the Atlantic are doing?
Yeah, I agree with what Tika said, and there's the opportunity there to be able to do that. I think it would be quite tricky without a framework and some guidance as well. So I agree that needs to be strengthened. I think what I would urge the step further that they can take where possible is to impose criminal liabilities as well, just to be able to support that even as they maybe use existing criminal frameworks where they can, or impose those even in the absence of existing framework for sanctions. That can be a good beginning to be able to support that complementarity as well.
Anton, let me bring you in as well. I don't know whether you have any thoughts in response to that specific question, but I'd also ask you to maybe think about the sorts of ideas that Sandra was putting forward regarding best practice, looking to other regimes and asking and trying to identify what works. Do you see a difference between things happening simultaneously or consecutively? Have you come up with any sort of specific idea about whether sanctions work better delivered all at once, or whether a rolling sanctions from different bodies around the world is more effective?
Well, I'm afraid I couldn't actually hear Sandra throughout, and technicians have been battling valiantly behind the scenes to change that, which I think is the reason why she cut out for a bit. But unfortunately, that didn't happen. In relation to the question about sanctions coordination, I think there's definitely a force multiplier effect. It is going to be particularly pronounced for countries like the UK. What I mean by that is that US sanctions are taken very seriously by financial institutions around the world anyway. So if you're a bank working in Europe, in the UK, anywhere in the world, you are going to be paying attention to US sanctions regardless. If you're someone else, for example, the UK, I think the force multiplier effect from the EU sort of channeling your sanctions as well, adopting them, is going to be very, very considerable. Another benefit of multilateral coordination is, I think, the validation of sanctions. We have to remember that as much as we care about the quality and strength of evidence, sanctions are imposed based on relatively relaxed evidentiary standards compared to, for example, court cases, even if we're talking about civil litigation. And so when it's not just one country, but it's a number of countries acting together saying, we think there's enough evidence there to designate that individual, I think there is this extra credibility that comes with that, which makes sanctions quite potent.
Thank you, Anton. Obviously, credibility is hugely important to take. I wonder, I know it's a very early stages question, but what sort of steps should the EU be taking to close legal vulnerabilities or loopholes and ensure that there is a robust regime?
Indeed, it's early stage and we are talking about hypothetical regime. However, we have a history of utilizing of EU sanctions and history of legal challenges EU has faced in the European Court of Justice between 2010 and 2015. It was a very difficult period for the Council where it has been losing a number of cases, and I think there is a good lesson drawn from there. Also from the previous misappropriation of state funds in Tunisia, Egypt, and Ukraine. There are a number of things the EU can do while it is still considering and deliberating on these sanctions. These are definitions, scope, and international standards. UK, for example, has taken UN Convention Against Corruption as a standard to rely to build its anti-corruption sanctions. We have less international standards on corruption than on human rights, understandably, but there is a convention. And UK, for example, took a bribery and misappropriation of the property, and it has a legislation and guidance notes which really describes in detail what these violations mean, and I think there are some lessons to be learned there. There is, of course, I cannot emphasize enough that the designation should happen based on the concrete evidence and not a presumption. Here I echo what Anton and Stephanie said. The role of civil society obviously is very, very important. If I was talking 10 years ago, I wouldn't dare to say this, but today we have so much of investigations out there from OCCRP, from international investigative journalists, from media. I think we can really rely and build cases based on the open source material. It's very important for the EU to do that. Unlike some of its partners, EU cases are challenged at the European Court of Justice, and the Council is obliged to present all the evidence based on which has formed the basis for the designations. And here also, in addition of the civil society, I think one thing that could be recommended or could be advisable is the dedicated expert working party within the Council on corruption. At the moment, there is none, which can inform both the evidence-gathering part and also the follow-up through it. I think it will be very important if this regime is to be in place for it to be strong, to have an expert definitions. And last thing I would like to say is the codification of the evidence. It's a little bit technical term, but it has been problematic for the EU to codify the evidence, to codify the evidentiary standards. It has struggled through the misappropriation of the state funds because of the absence of these issues. And I think this is something, even though those regimes have been a little bit of bittersweet memories for the EU, it can learn the lessons and build a new regime based on the lessons learned from those regimes.
Well, thank you. And I'm going to come back, Sandra, a specific question for you from Elizabeth Sessons. We're talking about if there is a regime, and obviously we were saying we're talking hypothetically. Concretely, though, is there a specific thing, entity, framework that's blocking such a regime? Is there some reason that we're not there already? Because if there is a will at EU level, and what sort of likelihood percentage would you put on it that we will have an anti-corruption sanction regime adopted by the EU, let's say, in the next 5 years?
Thank you. That's a very sensible question, but on which I'm not going to be giving too many responses because, of course, all discussions are confidential. No, what I can say, it's not that there is a specific entity blocking the idea. It is simply, to devise a new regime, if you would want to go down that road. It requires the answer to two important questions. One is that politically a choice that we want to be making, and then secondly, when you make that choice politically, how do you make this work legally? So both of these is still being had. So it is, I think, gaining maturity. Indeed, an openness to speak with other minor countries and that open to learn from their experience and to make sure whether the member states do want to go down that road, yes or not, or if they want to go down that road right now, some point in the future. It is not as if all of this specifically started off again. Global human rights regime was a process that took basically 2 years between the moment that the
Oh dear, Sandra, I think we've lost you again. But if you can hear me, I hope that I'm summarising correctly. If I'm paraphrasing by saying these things take time and there's a lot of moving parts when you come to do anything at EU level. And obviously, I do understand that you probably weren't going to answer that concretely by giving away what's happening behind closed doors when these negotiations aren't necessarily done in private. What I will do is that this question that what is the likelihood of the EU having an anti-corruption sanction regime adopted by the EU give us a percentage. That was one that came in again from Anrika Visser. And it's to all the panelists. So, Tika, do you want to put a percentage figure on how optimistic you are, how pessimistic you are, or even if you want to have a guess at a timeline or a time frame?
So it's a betting. Okay, I think if we didn't have the announcement by President von der Leyen in September, I would be very pessimistic at this point. But I think that is the first ever political declaration by the European Union official that EU will adopt this kind of regime. With that in mind, I feel quite confident with the minds Sandra has mentioned, with the issues, the legal issues, the unanimity, work needs to be done behind the scenes, but I feel confident we will arrive there, EU will arrive there, where it will have a solid anti-corruption sanctions regime. And this announcement in September gives me a big hope.
Steph, to you, the same question. How optimistic or otherwise are you? Obviously, political will behind it is a big positive.
Yeah, I think the necessity will become more clear over time. And if not the political will, then the necessity is going to drive it eventually. So I really hope that the EU can do it when it's at this level of maturing, as Sandra put it, rather than responding frantically to big events pushing the necessity of it. But I would say I am 80% optimistic. Perhaps just the timing and the form, but just to underscore that we're all here to support a very robust regime under the anti-corruptions and to underscore the potential impact this can have. It affects finances, it affects things that are close and dear to citizens. So there's a big opportunity here, and then the kind of the number of countries involved. I can't underscore the opportunity that represents enough to the EU. So that would be my call, together with the optimism there.
And Anton, the same question to you. What percentage level of optimism do you have? We've heard there, Tika mentioned, of course, Ursula von der Leyen's speech in the State of the European Union address. Is there also a sense that perhaps current, headlines, unfortunately, the war in Ukraine, but even something like FIFA corruption with the World Cup taking place in Qatar that we've seen, that actually focus on citizens' minds on this, and this could be used as a positive lever for change?
Well, I'm not a gambler, but I would safely bet my money on an EU anti-corruption regime coming into place in terms of the legislation being adopted. The real question to my mind is how it is then going to be used. So you can move very carefully and designate a couple of people who have already been processed by their home justice system, or a couple of people who are in exile from their countries because the government has changed there. You could do that. Or you could go after real cases of impunity. You could go after people who still keep running their countries, who keep sending their money to the collective West, and you can actually make sanctions matter. And the real challenge for the EU, I think, is how to go down that road and not just have an anti-corruption sanctions regime for the sake of saying that you have one.
No, thank you, Anton. That's absolutely true. I think, Tika, I'm going to give you the floor to say a few words as we wrap up. We've got just about 5 minutes left. Unfortunately, I think, Sandra, we may have lost you completely at this point, so I won't be able to give you the floor for your closing words, but I think we can see you, so give us a wave, please. I really do appreciate that you've taken the time. I know it's been a technical challenge. Thank you. Tika, so the floor is yours now to sort of, if you like, try and summarise where we've been at. What do you think needs to happen? What are the next steps?
Thanks a lot, and I would like to thank our colleagues from International Lawyers Project and to Sandra from External Action Service for joining us in this discussion, and for Steph and Anton taking the research, which will come out early next year, which hopefully will inform the discussion that's ongoing in the EU. In terms of the steps, there are many challenges as we discussed. This is not a black or white discussion. There is a clear need for adopting this kind of framework, but there are many how EU will do that, what kind of of designations and how it will assess the impact, how it will work with civil society, with like-minded partners, and this is a part and parcel of the whole discussion. In terms of the timeline, in terms of what we expect as the next steps, I will repeat what my colleague Carl said at the beginning. I think we would be looking forward to 9th of December to see the official announcement from High Representative. Even though the announcement was made by the Commission President, we need an official mandate for the High Representative discussions to move to more formal frame, so to say, and hopefully we can have, next year we can meet here with some more progress on this file. Thank you very much, everyone, and thanks a lot for your moderation.
Thank you, Tika. Indeed, thank you for everyone for joining online, and for those questions as well, some really excellent questions targeted very specifically for our panel. We know it's difficult to talk about hypotheticals, so hopefully, as you say, Tika, that next time we will be talking more concretely about specific plans, because I think there is a general agreement across the EU political level, certainly within the European Commission, that there is a need to sanction economic and financial enablers of human rights violations. That's just a given, and so at least that's some positive we can take away from today's short discussion. I know we could spend a lot more time going into more depth, but thank you all very much. Thank you, of course, to the Open Society Foundations for organising today. Do remember, share with your colleagues who perhaps couldn't follow along today. Use the various tools at your disposal. Go on social media, spread the word, and maybe tune in again for the next conversation that we'll be having on this very important topic. But have a great day.